Let's get started. Hi, thanks so much for joining HAP's webinar today over the essentials of estate planning. I'm Annette Piniazik. I'm the HAP's Director of Grants and Major Gifts, and we decided to launch this series in response to requests from a lot of community members who've been asking about estate planning. And our presenter for this series is Kathleen Wiesenthal. She's an attorney with Keever and Wiesenthal. And Kathleen's practice focuses on probate, real estate, and estate planning. And today she's going to talk about the general whys and hows of planning an estate. And we are recording this webinar. We're going to make it available on our website at a later date. And we have also reserved some time at the end of Kathleen's presentation for questions and answers. So you can always feel free to go down to the Q&A tab at the bottom of your screen and leave a question. And what we'll do is after Kathleen has finished her presentation, we can go through and, time permitting, answer as many questions as we can. Thank you so much. We really appreciate your attendance, and we really appreciate Kathleen doing this webinar presentation for us. Thanks.
Thank you. All right, good afternoon. I'm so glad that so many people are here to talk about and learn about estate planning. Estate planning is a vague term, maybe not even the best term to use to explain trying to plan for the end of your life, or also planning for your later life when you have incapacity or disability. And what estate planning and probate attorneys do is that we try to make sure that you have paperwork in place that are going to protect you and your assets and your children, so that you don't have chaos at the end of your life, or at the end when you are disabled. One of the things that I really feel strongly about is that everyone should have an estate plan. And I'm going to tell you about what's included in an estate plan and why everybody needs it, even if you don't have $12 million. I'm going to bring up my slideshow now. And we'll get started with it. Okay, so one of the things that I'm going to be talking about is what is actually included in an estate plan. I don't want that to be mysterious. It's not a mysterious thing. It is not only for the wealthy. It is for anybody who owns property, for them to have documents to protect themselves as a person, to protect their assets, to protect their home, and to protect their children. And some of the things that I'm going to cover today are the possibility of having a will in your estate plan, powers of attorney, and I'm going to explain the differences between the powers of attorney that are necessary. There are also going to be directives that I'm going to talk about, and the ones that are extremely important to you, and other plan documents that are available to you if the need arises. Everybody has a very unique situation in their lives. You may have the same documents as somebody else that you know, but they may not be the same documents. They're the same powers of attorney, or they're the same directives, but they're going to be unique to your situation, to your children, to your situation of health and disability, things like that. If you have a bank account, a home, a vehicle, or securities accounts, and that isn't the exhaustive list, you have an estate. You have assets that need to be protected, and they need to be handed over to the next generation, or to your spouse, or to your family if that's necessary for you. Even if you, well, especially if you don't have any children, it's very important for you to plan to make sure your assets get into the hands of people that you want to have your assets and that you think might take care of them for the rest of their lives. Not everything you own do you necessarily want to hand down to a family forever and ever, but if you do, let's try to make that happen in your estate plan. One of the things I'm going to talk about too, very briefly, is testamentary gifts versus a statutory inheritance. Testamentary gifts are those gifts which are given by a will. If somebody gives you a house in a will, then you are a beneficiary and you have received a testamentary gift. This gift will only be given to you after the death of the person who authored the will, the person who is the testator of the will. Statutory inheritance means that there is no will, or there's a gap in the will as to a particular asset. And that's a long story. We can talk about that later. The statutory inheritance is in the estates code, sometimes in the property code, and it is the discussion of who will receive your property if you don't have a will. Normally, what that does is, if you're familiar with the family tree, if you die without a will, and I'm going to use my hands to show you this family tree. If you die without a will, and you have no children, then your property is going to go up to your parents. If your parents are already deceased, then it will go to brothers and sisters. If brothers and sisters are already deceased, it may go to nieces and nephews. If you have children, it's going to go down towards the children, to your descendants. And that will also include grandchildren, if necessary, great-grandchildren, adopted children, if the situation applies. And those are the people that would inherit your estate if you didn't have a will. It's preferable to most people to have a will and say who you want to get your assets, rather than using the statutory regime. However, there are some people who their inheritance and descendants, their heirs, will all match the statutory regime anyway. And so sometimes a will not cause a great deal of chaos. It's just more expensive to probate that estate to move your assets for you. Okay, an estate planning attorney. This is why you need one. We're not just here to cost you money. We're here to actually smooth the way for you to be able to make a plan for all of your assets, so that you do not have to guess at what is going to be going out of your estate. They'll make you stop and think about the situations that might be important to you, the things that might come up. And we're talking about things like if you have a disabled person in the family, or an incapacitated person, or at some point, if you have an incapacitated person. Some of the facts that make up your case and make up your estate plan are going to be very, very unique to you. And we're going to want to address that as a team. The estate planning attorney is trained to see all of the bumps in the road, so to speak. For instance, my strength is that I also know real estate law, and I can make sure that your estate plan tracks your house through all of the heirs that you want to get the house, or all of your beneficiaries that you want to get the property. And it will also make sure that when you get to the point where somebody in the family has to sell that property, that you've got clear title. And that's one of my strengths, is that I can make sure that the title is clear on a piece of property. So every estate planning attorney brings a different strength to the table. Some people are really, really good at taxes, and they can make sure that if tax is your issue, there are estate planning attorneys out there that can make sure that you can minimize taxes to the best of your ability. And that would make it a lot easier on your family at some point when you pass away. Now, the assets that you have are actually characterized very, very easily. We're talking about assets, but that we're not talking about the fact that you have grandma's china or you have the silver set from great grandma. We're talking about assets that fall into major categories that each of those characteristics of those assets decide how they're going to be passed on to your family. So for instance, we may be talking about real property. So if we're talking about real property, which means land or improvements on the land, that would be specifically conveyed to your family one way, and a will can address that. And an estate planning attorney who has some real estate background can also make sure that they've got all the proper language in the will so that it's very easy to use the will as what we call a muniment of title. And the will can actually be the deed that transfers the property to your descendants, beneficiaries, heirs. Okay. For instance, personal belongings, such as it also what falls into there is checking accounts and vehicles, personal items in your home that aren't of a grand intrinsic value. If they are items such as paintings, artwork, other kinds of artwork, sculpture, whatever. Those kinds of things are considered personal items, and those are conveyed another way. The vehicles, and we all know that it's conveying vehicles is an interesting endeavor when you're trying to work with a Department of Motor Vehicles and also trying to make sure that a certain individual gets that vehicle. And then we also have securities accounts. Now, securities accounts are those things which, hold on a second. The securities accounts are those things which are held by a custodian, and such as your cash is held by a bank. Your bank is the custodian. CDs, usually held by a bank or other type of security company. IRAs, 401ks are usually held by a group such as Edward Jones, Raymond James, or Fidelity, things like that. And those custodial accounts, it's very, very important that if they have an ability for you to designate a beneficiary in those custodial accounts, you will be able to avoid probate for those accounts and have those funds go directly to your beneficiaries. However, if you have a minor child who's a beneficiary, there's a few more steps in there to make sure that there's a trust set up for the money for a minor child, or that the custodial account will be able to hold those funds until the child turns 18 or 25, whatever their rules are. Each custodial account has their own rules about what they need in order to give the money to the beneficiaries. If they, most of the time, they're going to need a court order. If you don't already have beneficiaries designated, they want to see death certificates, a court order, letters testamentary or letters of administration, which I'll go and discuss later. And they will want to have those custodial accounts because of their liability in just handing out money to your beneficiaries or your designated persons. They're going to make sure that the court order is going to match everything that you're telling them about who should be getting that account if there are no designations of beneficiaries. Many times on those custodial accounts, they will not if you're not a beneficiary, they're not going to tell you whether or not you're a beneficiary. And they're not going to tell you who is in most cases, unless you have a really close relationship with your bank or with your custodial company. The custodial accounts are supposed to be keeping and protecting the assets that are in there for the individuals who are the beneficiaries. How you get that information is when someone probates a will and they become the legal representative of that estate, either the executor, if you have a will, or if there is no will and you become an administrator of an estate. That's when those custodial accounts will be able to share information with you. So you might experience some frustration with them in the very beginning, but it will be taken care of. It will be, you'll reach a point where once you've probated an estate, where you will have the right to be able to get the information you need. Again, on vehicles, it depends on what you're doing with the vehicle. If you're simply changing the title on the vehicle, obviously you're going to want to have the original title in your possession. And as the legal representative of the estate, which only happens after probate, you'll be able to sign that vehicle over to whomever the will gives it to. All right. Homes and land is that's a seminar all to itself. And homes and land can be taken care of with a precision if you have an attorney who understands what you need to have in the documents, what information you need, and that attorney is able to take that information and make sure that it translates so that any third party that is going to either be buying the property or refinancing the property, something to that effect, will know who the owner of that property is now and how they received it. And that's something we'll go into later. Personal belongings, I already went over that. That includes your clothing, household effects, and things like that. Now, if you're a married person and all of these things have two names on them for each of these items, you are going to find that you're going to have to remember that in Texas, it's a community property state. And in Texas, it's everything you buy, sell, or handle, or acquire is part of the community property estate. And even if your husband's name, for instance, is not on the deed for a home that you purchased, or your wife's name's not on it, they still own half of it. It doesn't matter whose name is actually on the deed or the paperwork if you are married at that time. The only thing that are separate from community property attachment is those items that are inherited, gifted to you, or if you have acquired them through a personal injury case. Those kind of items are separate property to an estate, and they are not necessarily considered to be community property unless they've been commingled. So if you inherited $100,000 from grandma and you put it right into your checking account with your spouse, you've already commingled it, and it's going to be very difficult for you to say that was my money because you didn't put it in anything separate. If you receive a 401k account from a antecedent, and you have grandma or grandpa left you a 401k account or securities account, then if you kept that separate in that account, you would be able to call that your separate property. And the only reason this is going to matter is when we're putting the will together to make sure that we have dispersed all of your property where you want it to go. So you may have a list of persons that you want to be the beneficiaries of all your community property. You're one half of all of the community property, but you maybe want your separate property to go somewhere else. Maybe a brother, maybe just the oldest son, or something to that effect, or grandchildren. You might want to skip your kids altogether and do grandchildren. And that has to be handled differently in a will. So you've got to make sure that you've got a lawyer who's asking all the right questions. Okay. All right. So we're talking about death here a lot, and a lot of people think an estate plan is only for when you've passed away. But when you're alive, an estate plan is incredibly powerful and incredibly important for you to have paperwork in place. I can't even begin to tell you how I wish I could take everybody by the shoulders and just get them signed up for powers of attorney, because they're so important, and directives are so important, because if something happens to you, we are all living longer, and we're going to get older and probably more feeble as we get older, mentally and physically. And when you get to that point where mentally you can't handle your own estate, or you can't handle your own health, or make decisions about finances or legal matters or any kind of medical emergencies, those are the things that are going to cause some problems with your estate that you can avoid. We can definitely avoid these things so that somebody is still your voice, even though you are unable to make your needs known. So for instance, in directives are documents which you, as the testator, or as the actual individual who's swearing on these documents that you want this done for you, those documents are important to tell your doctors, your family, it could be financial people that you're giving these directives to also. But the directives are several things that are based on you having the opportunity to tell somebody when you no longer have a voice, when you can't make your needs known. That's your opportunity to tell everybody, this is what I would want. Okay. And now, okay, there's a lot of people who change their minds as they go through life. If you're doing an estate plan at age 30, you might feel completely different about a directive by the age of 70. Okay. A directive can include the directive to physicians, which is a document that tells a physician and your family that you, for instance, don't want to be kept on life support if you're in a terminal or an irreversible condition. You may want to be taken off any life-sustaining treatment and allowed to die naturally and comfortably. That's one of the key words there too, is that they want you to be comfortable. Or you can say, no, keep me on life-sustaining treatment. Never take me off. I don't want to die unless I die. And I don't want you to hasten it by taking me off life-sustaining treatment. Those documents are extremely important for you and your physicians and your family. Even if your family and you have had these discussions, when it comes down to that point in your life, you're going to want to have given your family the gift of certainty, and not being able to have that certainty is very painful for a family. We don't want that to happen. We want to be able to have you completely comfortable with the decisions that are made. And obviously you don't know what those will be. And when you come for a consultation about an estate plan, we'll talk about the different things that may or may not happen, and what your choices are. But again, we're talking about if you're alive and can't make your needs known. Now, guardianship paperwork versus the powers of attorney. If you have powers of attorney with your family, if you've given first of all, let me back up a little bit. The powers of attorney are at least two of them that you can do that are extremely important. The statutory durable power of attorney, which covers all legal and financial matters. You can give someone or several someone's agency to be able to act on your behalf while you're alive, but unable to handle your own legal, or financial affairs. That person will be given a great deal of power to be able to control your finances, continue to pay your bills, continue to pay for medical issues that might be coming up, continue to make decisions for you in case there are any legal matters pending. And it's the agent who will be in charge of making sure that your assets are secure and that they are protected and that you are being taken care of with those assets to the best of their ability to do so. And you can give your agent as many powers or as few powers as you want to be able to effect those changes for you. And that's another thing we'll talk about if you ever come in, or your attorney will talk to you about in great detail. The other power of attorney, which most of you have probably heard of, is the medical power of attorney. The medical power of attorney is for giving an agent the ability to make decisions for you and for your medical care, discuss it with the doctors and discuss it with nurses, social workers, insurance companies, pharmacies, things like that. And that power of attorney is also quite powerful, and it allows the individual that you've named, or the individuals, plural, to be able to make those decisions for you. Again, only when you're not able to make those decisions yourself, or you defer to them to make those decisions. The idea is that you should always still be in control of making your own decisions on both of these situations. Those documents are extremely important in making sure that somebody is able to make decisions for you with a third party, whoever that might be, and be able to do it without any risk to the third party. That's a lot of what's going on here, is that you want to give the third party the ability to say, well, I had a power of attorney for this individual, so I am able to listen to them and listen to any changes or orders that they want to give me in relation to this individual. Now, a HIPAA form, you may have heard about HIPAA releases. A HIPAA release is a release to an agent of information only. A HIPAA form does not automatically give anyone the right to make any decisions for you. So if you've got a HIPAA form within your medical power of attorney, that's extremely helpful. I also furnish HIPAA forms to my clients separately from the medical power of attorney. So if you only want your agent to be able to get information for you, like from the pharmacy or from the insurance company, you can do that without giving them the power to make any changes in your pharmaceutical situation, or in your insurance policy and things like that. Those powers of attorney are what will help you avoid guardianship at some point in your life. Guardianships are usually for people that have no powers of attorney, but the family has no power, no legal power to be able to help you or make any decisions for you in the event of your disability. That's a very tricky situation to be in. To be going into, let's say, assisted or nursing care, and assisted living or nursing care, and finding out that there's nobody there, that nobody in your family that can actually speak up legally and can give that third party home that you're staying in, or the facility you're staying in, give them some kind of authority to be able to speak on your behalf. A guardianship is only necessary when there are no powers of attorney, or if the person who has prepared the powers of attorney, you yourself, or your loved one, if they have revoked those powers of attorney, you may find yourself in a situation where a guardianship will be necessary to keep someone safe and to keep them alive and well. That's another conversation for another webinar also. Medical emergencies, if you have those, as you know, in a medical emergency, you don't have a lot of time to goof off and dither around with who's going to be in charge of any decisions for you, especially if you're incapacitated or you are in a coma or you're on a medical coma, things like that. You will want to make sure that you've got powers of attorney in place for medical emergencies. That may include something, such as DNRs. And a DNR is not something that most estate planning attorneys will put together for you because it's already a promulgated form. And you can access those by going online. And there are several different types, so you have to make sure you're getting the correct type of DNR. That's something else we would talk about in a meeting. Todd's and Ladybird deeds, you may have heard about those a lot, and no, it's not called Ladybird deed after Lady Bird Johnson. It just happens to be called that by, I believe it was an attorney who, I don't remember the whole details now. But anyway, I believe it was an attorney who called it a Ladybird deed, and we really don't know what the origin of that word was. A Todd is a transfer on death deed. Those are two types of deeds you can do for your property, either your homestead or your maybe some investment property that you might have. And you can do those before you pass away and even before you become incapacitated to give your property to a family member or family members, plural, and make sure that the people that you really want to receive it are going to get that property. So for instance, if you've got 4 grandkids, you love them all, but you only have one who really is going to need the house or has been helping you with the house, and you feel particularly comfortable with leaving the house itself just to that one grandchild, the will can still state that everything else you have is going to be split between the grandchildren, but you can prepare in the will a paragraph which will say it will go to Johnny, or you can prepare Todd and Ladybird deeds, which are revocable. The Ladybird deed, not always, but that's another matter. And the Todds are always revocable. You can file them in the real property records. And then when you pass away, that property automatically becomes the property of the individual that you've given that property to. Supported decision-making agreements are something else you can put into place. Let's say you're in a situation where you're the family member. You need to get mom or dad, they don't have the capacity to do powers of attorney anymore, but you might be able to get them to do supported decision-making agreements, which is it's an alternative to guardianship and will allow you to avoid guardianship and the expense of that. But the supported decision-making agreement will maybe get mom to say, yes, I want you to help me make some decisions when I'm in the hospital or if I'm living alone at the house, but I need some assistance with legal matters. Those decision-making agreements will be recognized by third parties, and it's a contract between you and that person talking about what you are able to do for them to assist them with their life functions. Maybe they need help paying their bills, and so they want you to be able to help them pay their bills, but not tell them what to do about paying their bills. You still leave decisions to them, but it helps them feel some autonomy and ask for help. And it's a very powerful document trying to be able to get assistance with life functions that you have to do. There are other alternatives to guardianship if there are no powers of attorney available, or if the person is beyond capacity to be able to give those, that we can talk about for individuals and depending on their diagnosis. Okay, we also have some information about let me back up one more. Sorry. Nope, didn't do it. So let me go backwards. All right, so if you have any other questions, and I'm going to stop my sharing now. If you have any other questions about specific things that might occur in your estate plan, you can always call an estate planning attorney. Be very careful to tell them everything. It's a very private kind of a conversation that you're going to have with an estate planning attorney. You really do have to tell them everything. If you have a blended family, you have to tell them all of that. If your husband had children outside your marriage, you have to tell us that. Or if the wife did. If you have situations where you've got disabled children, we need to know about that so we can make sure that the proper documents are in place, and the will sets up a testamentary trust for that incapacitated child. If you've got property that is not all in your name, if husband has the property in only his name, but it's community property, which we would investigate and do the background on that, you're going to want to tell your attorney that. You're going to have to talk about those things and have the opportunity to make sure that there's nothing left out in your will that's going to have to be handled by other means than a will itself. There are lots and lots of reasons to do a will and an estate plan, which is all these other documents we're talking about. I could go into lots of stories about some of the things that do happen, but so for instance, I have one story that I'd like to share with you. There was a lady who her husband passed away, and she had no idea that he had signed over her half of the property to all of his kids by having somebody stand in her place and sign. And the title company unfortunately allowed that to happen. They didn't check on the identification of the person who came to sign as her. Therefore, she lost her legally her interest in the property that they had shared and that she had also paid the mortgage for and paid the taxes for years and years and years. And she came to me to work out how to get that property back, how to make sure that she still had her home after all this time, how to work out with the kids that were his children, to make sure that there was nothing else that he had hidden from her to keep her out of the loop of inheriting what she thought was hers all along. There are lots of things that never are hidden from you, and that's wonderful. That's the way it should be. But if there are things that you have questions about, or you're a little nervous about, or you have a blended family, let me say right now that on a blended family, if either spouse has children outside the marriage and doesn't have a will, their half of all community property is most likely going to go to their kids, not to the spouse. There are exceptions to that, and there's exceptions such as life estates that also go along with that explanation. But you've got to be really careful. Don't assume a spouse is going to automatically get the assets of an estate just because they were married, because that may not be the case. Those are the kinds of things that you want to talk with an estate planning attorney about. And these are the guidelines to help you try to get everything into order for your own children and for yourself too. And maybe have a conversation with your spouse about what's in their estate plan. I think I'm finished with my conference so far. And if there are any questions.
Thank you so much, Kathleen.
You're
Everything
welcome.
was so helpful and so informative, and we have quite a few questions.
Okay.
Before we get to them, I just wanted to let everyone know that Kathleen's going to be back for another webinar, and this one she'll be delving farther into different powers of attorney, and that will be the topic. That's going to be on Friday, January the 24th, and we'll make sure that everyone has links so they can sign up to be Kathleen's audience for that one. And Kathleen is also going to be speaking at our HAPS Caregiver Conference, and that's going to be on Saturday, November the 9th. So we really appreciate everything that you're helping our HAPS audience and HAPS community with, Kathleen. Um, I'm going to go into some of the questions here. As I said, we've got quite a few. The first one we received says, my question's about transfer on death deed. Our home is in my husband's name, purchased prior to our marriage, and we have a will in place. What is the advantage of a transfer on death deed versus allowing the home to go through the probate process?
They're both identical in terms of the outcome. If you have it transferred by will, that's fantastic. It'll still go to the spouse if that's what they have said in the will. The transfer on death deed just gives that little bit of extra surety. It gets filed in the real property records. It has to be revoked in writing in the real property records if the spouse decides they don't want to leave it to you anymore. The Todd is kind of like belt and suspenders. If you have already given all of your assets to your spouse, that's going to do it in the will. You're okay with that. The Todd, for instance, if it's not about a spouse, let's say it's about a child, you may want only the one child to get that house rather than all three of the kids or whatever the situation may be. And a Todd will help settle that argument right away because it's already been done, so to speak. And when you pass away, it's automatically transferred. If a house is separate property for a spouse, and you would like, if that spouse wants to give that entire property to their spouse when they pass away, the will or the Todd will be perfectly fine to be able to make that very clear.
Okay, we have another question that's also going into the house theme. And someone has asked, what if the home was acquired before marriage, but after the marriage, the non-owner made most of the payments on it?
If it was acquired before the marriage, did they mention whether or not there are any children involved that are outside the marriage?
No.
They didn't mention that? Okay. If someone acquires a piece of property before marriage, that will never be community property unless it's legally stated in a deed, in a will, or something well, obviously in a will that wouldn't make any sense because it's not community property anymore. But if it will always have to be done formally for a spouse to become an owner of a piece of real property. If it's in somebody else's name, separate property in Texas is sacred. And you will find not many people and not many judges who are going to change the character of separate property to community property, even if it means the spouse is homeless. Now, let's say somebody doesn't do a will and they have a piece of property that belonged to them only. Let's say it's the husband and the husband passes away. The wife will get a life estate in that property, which is a phrase that it's a legal right to property that will allow that individual to be able to live in that property for the rest of their life, and nobody can remove them from that property unless they abandon it.
Okay, thanks. Another question. Can someone who is not a US citizen living overseas be named as beneficiary? Will this beneficiary be taxed in the US before the beneficiary receives the money?
Now that about the taxes, I have no idea. I am definitely not a tax attorney. You will not see that anywhere in my bio. So you would probably want to contact a CPA or a tax attorney regarding that kind of situation. However, yes, somebody who lives outside the United States can be a beneficiary. The only time that it's going to be difficult is if they want to be an executor. And I say difficult, not impossible. If they want to be an executor or if they're going to be an administrator of an estate, that will be difficult because the court has to have some kind of legal power over the individual. And if they're a US citizen, obviously, it's much easier, a Texas citizen. So.
Okay, another question, which says, so you can sign HIPAA forms allowing your daughter to be given info if you're in the hospital, but without a power of attorney. She wouldn't be able to make any medical, she wouldn't be able to make my medical decisions.
That's the theory. Okay. Now, there are some hospitals, and I think everybody's been in that situation where you go to the hospital and everybody tells you everything. You're fine. And that does happen sometimes if they know you to be a family member. Sometimes they don't feel the liability and a doctor isn't concerned or the nurse isn't concerned. But there are some hospitals that are very, very careful with HIPAA information. And so unless you have a HIPAA release that allows them to talk to you about a case, they won't be able to talk with you. If you do not have a medical power of attorney, it means you don't have any power to make any decisions on behalf of these individuals. So those kinds of uh, documents are going to be important if you want somebody to be able to make individual decisions. If someone has already passed that point and they don't have the capacity to do that, a HIPAA might be the only thing that family member can do to assist with getting information and then hopefully talking the doctors into it, giving them help.
Hey, thanks. And someone else wants to know what the difference is between a Todd and a ladybird deed, and what are the tax considerations of of these.
Okay. Tax considerations, from my very rudimentary knowledge of taxes, okay, when you give somebody a piece of property at your death, they will have to pay if it's over 13 million.06 today, then they will have to pay an inheritance tax. There is no income tax in Texas. Wherever you might be, you may be having to pay some kind of a tax on an inherited piece of property. There is no tax benefit that I'm aware of for either of them, one over the other. Okay. The ladybird deed is a deed that you do. It can be individualized for the person who is preparing the deed and giving the deed to the beneficiaries. It really can't be revoked, but there's a lot of attorneys who say it can. So that's a philosophical discussion. A Todd is revocable. It's definitely revocable because you haven't given the property to anybody yet. You are only notifying them that they will be a beneficiary once you've passed away. A ladybird deed actually gives, okay, so Annette, I give you a piece of property in a ladybird deed, and I say, I'm going to keep a life estate and the ability to sell the property if I want to. That's a ladybird deed, okay? If I sell the property, then you don't have anything, obviously, when I pass away. If I continue to hold that property and when I pass away, you receive that property from me under the ladybird deed, my life estate will have gone away because I've passed away, and then you will be the recipient of that property. There are many things you can put in a ladybird deed that can change that outcome. That's what's different between the two. A Todd is pretty straightforward. A ladybird deed is a little bit more like Medicaid planning, for instance.
Okay, another question. If I've created a will when my son was a minor, do I need to now make changes now that he's an adult?
No, not unless you want to make him an executor or a trustee in any trust that might exist. The fact that he is of age now has no bearing. If there was a contingency trust set up in that will that made arrangements for if he was under the age of 18 or 25 or whatever that might have been, if those terms exist in the will, they just won't be important in the will. They can be ignored because he's already 35, that kind of thing.
Okay, another question. Do you have to probate if you have a will?
Not always. I've actually told some people maybe they don't have to. What will happen though is that families when somebody first dies, you say, oh, he only had a checking account and he only had this. Well, guess what? He also had an insurance policy and he didn't have a beneficiary. So if you don't probate that will within the 4 years, you have 4 years to probate a will. Otherwise, you have no legal authority to become a representative of that estate. So if there's an insurance policy that comes up and they require that there be an executor or an administrator of that estate in order to claim the insurance policy or whatever the asset might be, because you probably have more of an imagination of what there could be that will come up, you're going to want to probate the will just to be sure. Now, 4 years is a pretty long time, and you may have gotten most of the information you're going to get about assets of an individual. But it does happen that after the 4 years, people find an asset. And I actually had somebody who had a couple $1,000s worth of an asset somewhere, and it was past the time that they could probate the will. And the particular custodian of that money wouldn't accept a small estate affidavit, and they wouldn't accept an affidavit of heirship, which is another matter too. Affidavit of heirship is something you can do outside of court that sometimes third parties will accept that. But this custodian wouldn't accept that. And so they literally, without having to go and do probating the will as a muniment of title, they would end up, how did we decide that? Oh, they would have ended up paying almost exactly what they would have gotten from this particular account. So they passed on that. They passed on probating the will, even though, again, they'd waited way too late. They were like 3 months away from the 4 years. So yes, you can do a will, and maybe at the end of someone's life, they don't have any assets left to probate. That is acceptable, but you probably should seek some advice first before you make that decision.
Okay, and keeping with the probate theme, someone wants to know if having a Todd circumvents probate. It says probation, but probate.
Yeah. Yes, it can. It can do that. If the only asset that some lovely old lady has in her estate, 'cause she's already spent all her funds, the only asset she's got left is a house. Yes, a Todd is definitely something she could do to avoid having to go through probate and still give her biggest asset to whomever she wants to have that. And yes, that could avoid probate altogether. But again, be cautious that there aren't other things that you're going to need a court order for. That's the most important thing to remember.
Okay, someone wants to know if you could share any resources to carry out executor functions when you're the designated executor named in a will.
Yeah, there are actually a couple of companies that are starting now that actually will become the executor for your estate once you sign a contract with them. If you are designated as an executor and you really don't think you want to do it, or you can't, or the family dynamic is just such that it's like too painful, then you can find someone to be an executor for that estate and appoint them as long as the whole family agrees to that. Any changes from the will probably require family unanimous consent.
Okay. Another question, how would I deal with making provisions for my disabled husband if I should pass before him? We have no children, but he does have a sister that he's not particularly close to, and they don't want her to have control of their estate.
Okay. And I'm assuming this husband has no will at this time?
This is what I have on the question.
Okay.
So,
Okay.
yeah,
Sounds like that. Yeah.
yeah.
That's going to be difficult because if he does not have the capacity to do a will, which is a pretty high, it's pretty high capacity. You have to be able to understand what you own, who is it going to go to, and what it is you're doing by preparing a will and signing a will. If they don't have that kind of capacity, then you've got a situation where you can't do powers of attorney either if the capacity is the issue. If your husband still has capacity to do these things, I would get in touch with an attorney as soon as possible and try to get some powers of attorney set up and perhaps a simple will to make sure that he gives that his assets go to the people he wants them to go to. Yeah.
Okay. Question, if you have a stepson and his dad and I both have a will, is the stepson entitled to inherit a percentage of my estate?
Absolutely not. Not if you don't list them as your child. In a will, there's a paragraph where you can list all the children that you have, and they may include adopted children, stepchildren. That's your call when you fill out a will. If you do not have that individual in your will, or if you specifically say, I am not making provisions for them in this will because they are well taken care of, or something to that effect, you're actually making sure that they won't accidentally receive some of the assets of the estate. Not disclaiming, what's the word? Excluding somebody from your will is a really important thing, as well as including people, because you don't want to offend them. And we all know that you don't want to offend them, but you also want to make sure that they don't accidentally get some of your estate because they were your children. So,
Okay, we are almost out of time. I'm just going to have one more question for you, which someone wants to know if you have to see an attorney if you want to make amendments to your will.
you don't have to, but I would suggest that you at least discuss it with an attorney, at least have a consultation to find out if that's going to change the way any of your assets are going to pass to your beneficiaries. If you're changing executors or anything like that, you can probably just do a codicil. And if anybody is into Googling, you can probably Google a codicil, but I'd prefer you go see an attorney, because there may be one fact that's going to change the way that will is handled. And I could go into that for hours, but you really want to make sure that you're giving yourself good advice. So,
Well, our time is up. I just wanted to thank Kathleen Wiesenthal again and to remind everyone that we're going to have another one of our webinars dealing with estate planning. And she's going to be talking about powers of attorney at length. And that will be on Friday, January the 24th. And Kathleen's also going to be speaking at our HAPS Caregiver Conference, which will be Saturday, November the 9th. Please be sure and look on our haps.org website to get any further information about these. Follow us on social media. We're on Instagram and on Facebook, and we definitely do our updates there. Kathleen, thank you so much.
you're very welcome.
Everyone out there, thank you so much for being part of our webinar, and hope you guys have a wonderful weekend.
Have a
Thanks.
good week. Thank you.
Bye.
Bye.